I never expected my medical alert system would turn my peaceful Phoenix neighborhood into a war zone, but Brenda Carmichael made sure it did. The trouble started on a Tuesday morning in late March when I heard the sharp rap on my door that would become all too familiar over the next few weeks. I was expecting my daily check from Lifeguard Medical Services, the company that monitored my heart condition and sent a nurse to verify my vitals every morning at 9. What I was not expecting was Brenda Carmichael, president of the Saguaro Hills Homeowners Association, standing on my doorstep with her lips pressed into a thin line, and her phone already raised like a weapon. I am Quinton Larson, 52 years old, and I have lived in this neighborhood for 8 years. I bought my house at 4256 Desert Rose Drive when my wife was still alive, back when the HOA was run by reasonable people who understood that life happens, and not everything needs to be micromanaged. Then Brenda took over 2 years ago, and suddenly every blade of grass was measured, every paint chip scrutinized, every visitor logged and questioned. My heart condition developed about 6 months ago. Arrhythmia, the doctors called it, along with some fancy Latin terms that essentially meant my ticker could decide to quit without much warning. After a particularly bad episode that landed me in Banner University Medical Center for 3 days, my cardiologist doctor Rahman insisted I sign up with Lifeguard. They would monitor me remotely through a device implanted under my skin, and a nurse would visit daily to check my readings and make sure I was still breathing. It was not glamorous, but it kept me alive and out of the hospital. The white van with the blue medical cross on the side had been parking in my driveway every morning at 9 for the past 3 weeks. Nurse Patricia would come in, take 15 minutes to check my vitals, update her tablet, ask me a few questions about my symptoms, and leave. Simple, professional, life-saving. Apparently, Brenda had other ideas. "Mr. Larson," she said when I opened the door, not bothering with pleasantries, "we need to discuss this commercial vehicle situation immediately." I blinked at her. "Commercial vehicle?" She gestured dramatically at the Lifeguard van sitting in my driveway. Nurse Patricia was just getting out, her medical bag in hand. "That. It is a clear violation of our HOA covenants, Section 4, Paragraph 12, which explicitly states that no commercial vehicles may be parked in residential driveways between the hours of 8 p.m. and 8 a.m. "It is 9 in the morning," I pointed out. "And it arrives every single day, creating an eyesore and reducing our property values," Brenda continued as if I had not spoken. "I have received multiple complaints from neighbors. This was news to me. I got along fine with my neighbors. The Hendersons on my left were retired and friendly. The Martinez family on my right had 3 kids who sometimes helped me with yard work. Who exactly was complaining?" Nurse Patricia approached, and I could see her taking in the situation with the practiced eye of someone who had dealt with difficult people before. "Good morning, Mr. Larson. Is there a problem?" "No problem," I said. "Just a misunderstanding." "There is no misunderstanding," Brenda snapped. "This is a clear covenant violation, and I am obligated to enforce our community standards. If this vehicle continues to appear daily, you will face fines starting at $100 per occurrence." My chest tightened, and not in the good way. This is a medical service. I need daily monitoring because of my heart condition. Brenda's expression did not soften 1 millimeter. "Then they can park on the street. Or you can arrange for home monitoring that does not involve a commercial vehicle. Our covenants exist for a reason, Mr. Larson. Everyone must follow the same rules." Nurse Patricia set her bag down. "Madam, I am legally required to provide in-home medical care to Mr. Larson under his treatment plan. This is protected under the Fair Housing Act and the Americans with Disabilities Act. Medical service vehicles are exempt from most HOA vehicle restrictions. I could have kissed her right then. Brenda's face flushed red. "I know the law, young lady," Brenda said in a tone that suggested she absolutely did not. "And I know that homeowners associations have the legal right to enforce their covenants. If Mr. Larson has a medical issue, he can take it up with the board at our next meeting. Until then, this is a violation, and it will be treated as such." She turned on her heel and marched back to her car, a silver Lexus that was always immaculately clean. I watched her drive away, feeling that familiar flutter in my chest that meant my heart was not happy. "Let me check you," Patricia said gently, guiding me inside. "That kind of stress is not good for you." She was right. My readings were elevated, and she made me sit quietly for an extra 10 minutes until everything normalized. While I sat there with electrodes stuck to my chest, she made a phone call to her supervisor and explained the situation. I heard words like reasonable accommodation and legal precedent and documentation. "We have dealt with this before," Patricia told me after she hung up. HOAs sometimes think they are above federal law. They are not. My company will send a formal letter to your HOA explaining that medical service vehicles are legally protected. Do not worry about it. But I did worry. I had lived under Brenda's regime long enough to know that she did not back down easily. She collected violations like some people collected stamps, and she took personal offense when anyone challenged her authority. Sure enough, 2 days later, I received a formal violation notice in the mail. $100 fine for unauthorized commercial vehicle parking. The letter was printed on official Saguaro Hills HOA letterhead and signed by Brenda in her capacity as president. It referenced Section 4, Paragraph 12 of the covenants and gave me 10 days to pay or face additional penalties. I called Lifeguard's legal department. They assured me they had sent a detailed letter to the HOA explaining the federal protections. They told me not to pay the fine and to document everything. I started taking photos of the van in my driveway each morning, time-stamped and dated. Brenda did not appreciate being ignored. The following Monday, she was back at my door at 9 a.m. sharp, this time with her phone actually recording video. "Mr. Larson, I am documenting this ongoing violation for HOA records," she announced loudly. "This is day 4 of your refusal to comply with community standards." "I am not refusing anything," I said, trying to keep my voice level. "This is legally protected medical care." "That is for a court to decide," Brenda said. "In the meantime, you are in violation and the fines will continue to accrue. That is now $400 you owe the association." Nurse Patricia arrived again, and this time she was not as patient. "Madam, you are interfering with medical care. I need you to step away from the property so I can attend to my patient." "I am on the driveway, which is common area subject to HOA rules," Brenda shot back, which was absolutely not true. "My driveway was part of my property." "Actually, it is not," I said. "My property line extends to the sidewalk. You are trespassing." Brenda's eyes narrowed. "Are you threatening me, Mr. Larson?" "I am stating a fact. Please leave my property." She left, but not before making a show of taking more video and muttering about uncooperative homeowners and declining neighborhood standards. That afternoon, I got a call from my neighbor, Robert Henderson. He sounded uncomfortable. "Quinton, I wanted to give you a heads up," he said. "Brenda came by earlier asking if your medical van bothered me. I told her no, that I barely notice it, but she seemed to be going door to door." "Did anyone say it bothered them?" "Not that I heard. Most people think she is being ridiculous, but you know Brenda. Once she gets something in her head, she does not let go." That was the truth. I thanked Robert and spent the rest of the day researching HOA law in Arizona. What I found was both encouraging and frustrating. Federal law absolutely protected my right to receive medical care, and courts had consistently ruled that HOAs could not restrict medical service vehicles. But I also found horror stories of HOAs dragging homeowners through years of legal battles, racking up thousands in legal fees even when the HOA was clearly in the wrong. I did not have thousands of dollars for legal fees. I was on disability after my diagnosis, living on a fixed income. My savings were decent but not infinite, and I could not afford a protracted legal war with an HOA that had deep pockets funded by everyone's dues. The next morning, Wednesday, things escalated. I was in my kitchen making coffee when I heard sirens outside. Multiple sirens. I looked out my window and felt my heart sink. 2 Phoenix Police Department cruisers were parked in front of my house, and Brenda was standing on my lawn talking animatedly to 2 officers. I went outside before they could knock. The officers turned to me and I could see them sizing up the situation. One was a young guy, maybe late 20s, with a name tag that said Officer J. Morrison. The other was older, probably in her 40s, with Officer R. Chen on her badge. "Mr. Larson," Officer Chen asked. "That is me." "What is this about?" Brenda jumped in before the officers could answer. "I called because this man is running an illegal business out of his home. That medical van is here every single day, clearly operating a commercial enterprise in violation of our residential zoning and HOA covenants." Officer Morrison looked at the lifeguard van, which had just pulled up right on schedule. He looked back at me. "Is this your vehicle, sir?" "No, it belongs to Lifeguard Medical Services. I am a patient. They monitor my heart condition." "He claims it is medical," Brenda interjected, "but there is no way to verify that. For all we know, he could be running any kind of business out of his garage." Officer Chen held up a hand. "Madam, let us handle this." She turned back to me. "Mr. Larson, can you explain the situation?" I did. I explained about my arrhythmia, my hospitalization, Dr. Rahman's orders, the monitoring device, the daily check-ins. Nurse Patricia had joined us by then, and she corroborated everything, showing her credentials and explaining the medical necessity. Officer Morrison looked distinctly uncomfortable. "Madam," he said to Brenda, "this appears to be a legitimate medical service. We cannot and will not interfere with someone's health care." "But the HOA covenants," Brenda started, "are a civil matter," Officer Chen cut in firmly. "This is not a police issue. If you have a dispute with your homeowner, you need to handle it through your HOA's proper channels or civil court. We are not here to enforce HOA rules." Brenda's face went through several shades of red. "So you are saying he can just violate our community standards with impunity?" "We are saying this is not a criminal matter," Officer Chen repeated. "In fact, interfering with someone's medical care could potentially be a problem. I would suggest you consult with a lawyer about the Americans with Disabilities Act before you continue down this path." I could have hugged that officer. Instead, I just nodded gratefully. Brenda was not done. "I demand you file a report at the very least. This needs to be documented that I made a good faith effort to resolve this situation." Officer Morrison shrugged. "We will file a report that we responded to a call about a medical service vehicle and determined no law was being broken." "Is that what you want?" It clearly was not what she wanted, but she huffed and said yes anyway. The officers took a few notes, got statements from all of us, and prepared to leave. Before they drove away, Officer Chen came back to me. "Mr. Larson, I would strongly suggest you document all of this. If your HOA continues to harass you about your medical care, that could potentially become a discrimination issue. You might want to consult with a lawyer yourself." "I appreciate that," I said. "Thank you for being reasonable." She smiled slightly. "We see a lot of HOA calls. Most of them are not police matters. Take care of yourself." Brenda left shortly after the police, but I could practically see the steam coming out of her ears. Nurse Patricia checked me twice because my heart rate was through the roof. "This is dangerous for you," she said seriously. "This kind of ongoing stress could trigger a serious cardiac event. I am going to document this in your file and report it to Dr. Rahman. You might need legal protection here." She was right, but I felt trapped. I could not move because selling a house with an active HOA dispute was nearly impossible. I could not afford a lawyer. And I absolutely could not skip my medical care just to appease a power-hungry HOA president. That evening, I got a call from another board member, a guy named Tom Fletcher, who I had played poker with a few times before Brenda took over. He sounded apologetic. "Quinton, I heard about what happened today. I want you to know not everyone on the board agrees with Brenda about this." "Then why are you letting her do it?" he sighed. "It is complicated. Brenda has a lot of support from certain homeowners, the ones who care more about property values than people. And technically, the covenant language is broad enough that she can argue it applies. I have been trying to convince the other board members to create an exception for medical vehicles, but we need a majority vote, and Brenda is fighting it hard. So what am I supposed to do in the meantime? Pay her ridiculous fines? God, no, don't pay anything. That could be seen as admitting fault. Just keep doing what you are doing and let the lawyers sort it out. I am hoping this will blow over once Brenda realizes she cannot win." But Tom did not know Brenda like I was coming to know her. She was not the type to admit defeat. The next violation notice arrived on Friday. $800 in accumulated fines. The letter threatened to place a lien on my property if I did not pay within 30 days. It also informed me that I was being summoned to a disciplinary hearing before the HOA board the following Tuesday evening. I called Lifeguard's legal department again. This time, I spoke with a lawyer named Sarah Kowalski who specialized in healthcare access issues. She was blunt. "Mr. Larson, your HOA is violating federal law. The Fair Housing Act requires them to make reasonable accommodations for individuals with disabilities. Daily medical visits absolutely qualify. The ADA backs this up. You have a strong case, but these things can take time to resolve." "How much time?" "Months, potentially. Maybe a year if it goes to court. HOAs have to be sued into compliance sometimes." My heart sank. "I cannot deal with this stress for a year. It is literally killing me." "I understand. Let me make some calls." Sometimes a strongly worded letter from a law firm is enough to make them back down. If not, we might need to pursue an emergency injunction to stop them from fining you while we sort this out. She told me not to attend the HOA hearing without representation. She said anything I said could be twisted and used against me later. Instead, she would send an attorney to represent me. The weekend was tense. I barely slept. Every time I closed my eyes, I imagined my house being taken away, liens piling up, legal bills drowning me. My chest hurt constantly, and I had to use my emergency medication twice, which I was only supposed to need once a month. On Monday, Brenda struck again. This time, she had rope barriers placed at the end of my driveway with a sign that said, "No commercial vehicles beyond this point." When Nurse Patricia arrived, she had to park on the street and walk up my driveway. "This is getting absurd," Patricia said. She took photos of the barriers and the sign. "My company is filing a formal complaint with the Arizona Department of Health Services. This is interference with medical care." I felt helpless. Brenda was everywhere, documenting everything, making my life miserable with the absolute conviction that she was in the right. The HOA hearing on Tuesday night was held at the community center, a bland building at the edge of our neighborhood that hosted everything from bingo nights to contentious board meetings. I arrived with Sarah Kowalski, who had driven up from her office in downtown Phoenix. She was in her mid-30s, sharp-eyed and professional, carrying a briefcase thick with documents. The board sat at a long table at the front of the room. Brenda was in the center, flanked by 4 other board members. Tom Fletcher, who gave me an apologetic look. Margaret Wu, an elderly woman who usually seemed reasonable. David Price, a younger guy who always agreed with whatever Brenda said. And Linda Morrison, a middle-aged woman I did not know well. About 15 other homeowners were scattered in the audience. Some I recognized as Brenda's supporters. Others were people who just liked drama. Brenda called the meeting to order with all the ceremony of a judge in a capital case. We are here tonight to address the ongoing violations at 4256 Desert Rose Drive, currently owned by Mr. Quinton Larson. Mr. Larson has accumulated $800 in fines for repeated commercial vehicle violations and has refused all attempts at resolution. Sarah stood up. For the record, I am Sarah Kowalski, attorney representing Mr. Larson and Lifeguard Medical Services. My client has not violated any HOA rules. The vehicle in question is a medical service vehicle, which is explicitly protected under federal law. Your opinion is noted, Brenda said coldly. However, this board is responsible for enforcing our covenants, which all homeowners agreed to when they purchased their property. The covenant is clear about commercial vehicles. The law is clearer, Sarah shot back. She opened her briefcase and pulled out a thick stack of papers. I have here copies of the Fair Housing Act, the Americans with Disabilities Act, and 17 court cases from Arizona and other jurisdictions where HOAs attempted to restrict medical service vehicles. In every single case, the court ruled in favor of the homeowner. You cannot restrict access to necessary medical care. It is that simple. Margaret Wu spoke up. Ms. Kowalski, I understand the legal argument, but our concern is also about setting precedent. If we allow one commercial vehicle, where do we draw the line? You draw it at the law, Sarah said flatly. Medical necessity creates an exception. That is not a slippery slope. It is a clear legal standard. Mr. Larson has a documented heart condition that requires daily monitoring. This is not optional. This is not cosmetic. This is life-saving care. David Price leaned forward. How do we even know that is true? How do we know he is not just using this as an excuse? I felt anger flash through me. Sarah put a hand on my arm, keeping me seated. That is an incredibly inappropriate question that borders on harassment, Sarah said. But since you asked, I have here a letter from Mr. Larson's cardiologist, Dr. Rahman at Banner Health, explaining the medical necessity. I also have documentation of Mr. Larson's hospitalization in October and the subsequent treatment plan. This is all protected health information that Mr. Larson is not legally required to share with you, but he is providing it voluntarily to resolve this matter. She passed copies to the board members. I watched them read, saw their expressions change. Even Brenda looked slightly less certain, though her jaw remained set. Tom Fletcher cleared his throat. I move that we dismiss all fines against Mr. Larson and create a written exception in our vehicle policy for documented medical service providers. I second, Margaret said immediately. Brenda's eyes flashed. We have not finished the hearing. I have not presented all the evidence. What evidence? Tom asked. This is pretty cut and dry, Brenda. The man needs medical care. We cannot stop that. We are not stopping anything, Brenda insisted. We are simply enforcing reasonable community standards. There are other options for medical monitoring that do not involve daily vehicle visits. Mr. Larson could move to a facility with on-site medical staff. He could arrange for telehealth services. He is choosing the option that violates our covenants. The room went very quiet. Sarah's expression turned glacial. Are you seriously suggesting that Mr. Larson should move out of his home or accept inferior medical care to satisfy HOA aesthetic preferences? Sarah asked. I am suggesting that living in a covenant-controlled community comes with responsibilities, Brenda said. This is discrimination, Sarah stated flatly. You are telling a disabled person to move because his medical needs inconvenience you. That is textbook Fair Housing Act violation. I will be honest with you, Miss Carmichael. I came here tonight hoping to resolve this amicably. But if this board does not immediately dismiss all fines, create a medical exception policy, and provide written assurance that Mr. Larson will not be harassed further, I will file a federal discrimination lawsuit by the end of the week. Several homeowners in the audience gasped. David Price looked worried. Linda Morrison was reading the medical documents Sarah had provided, her face troubled. Margaret Wu spoke again. I think we need to vote on Tom's motion. All in favor of dismissing the fines and creating a medical vehicle exception. Tom and Margaret raised their hands immediately. After a long moment, Linda raised hers too. That was 3 out of 5. Brenda and David kept their hands down. Motion carries, Margaret said. The fines are dismissed. Brenda looked like she had bitten into something rotten. This is not over. I am going to consult with the HOA's attorney. This decision may need to be reviewed. Consult with whoever you want, Sarah said. But if Mr. Larson receives any more harassment about his medical care, we will take legal action. I am putting that on the record. The meeting dissolved after that. Several homeowners came up to me afterward, apologizing, saying they had no idea what Brenda was doing. Robert Henderson was there and clapped me on the shoulder. Glad that is settled, he said. Brenda has been out of control lately. But I could tell from the look on Sarah's face that she did not think it was settled. As we walked to our cars, she confirmed my suspicion. That woman is going to keep pushing, Sarah said. I have seen this before. Some HOA officers become obsessed with control. They cannot accept losing. You need to be prepared for her to try something else. Like what? Who knows? Trumped-up violations for other things. Harassment. Maybe she will try to get you voted off the neighborhood or push for your house to be foreclosed on some technicality. Document everything. Every interaction, every letter, every phone call, and call me immediately if anything happens. I drove home feeling exhausted and anxious despite the victory. My chest ached, and I had to sit in my car for 10 minutes doing breathing exercises before I could go inside. Sarah was right to be worried. For about a week, things were quiet. The lifeguard van came every morning. Nurse Patricia did her checks. No one bothered me. Then the new violation started. First, it was my mailbox. Apparently, it was 3 inches too far forward from the property line. $50 fine. Then my grass was allegedly a 1/4 inch too long in the front yard. Another $50. My house number was supposedly the wrong shade of bronze. $75. I had a small crack in my driveway that needed to be repaired immediately. $100. Each violation came with photos, measurements, and citations to obscure covenant provisions I had never heard of. Each one was signed by Brenda. I started getting 2 or 3 violation notices a week. I called Sarah after the 5th one arrived. She is trying to bury me in fines for made-up problems. I know. Start documenting everything. Take your own photos showing that these violations are either false or trivially minor. Have your neighbors do the same. If we can show a pattern of harassment, we can get a restraining order. I did what she said. I took photos of my mailbox, which was exactly where it had always been and in line with everyone else's on the street. I measured my grass, which was well within the acceptable range. I checked my house numbers against 3 other houses on my block that had identical numbers in identical finishes. Robert Henderson went a step further. He took photos of violations on other properties, including Brenda's own house, where her grass was just as long as mine, and she had a crack in her driveway twice as large as my supposedly problematic one. "She is not enforcing the rules," Robert said, showing me his photos. "She is targeting you specifically. That is harassment." Sarah filed a motion for a temporary restraining order, asking the court to stop the HOA from issuing any more fines or violations against me until the discrimination case could be heard. We had a hearing scheduled for early May. Brenda did not stop. If anything, she intensified. She started showing up at my house at random times, taking photos, measuring things, walking the property line. She filed a complaint with the county claiming my fence was improperly permitted. She called code enforcement about my trash cans being visible from the street. Every complaint was investigated and dismissed. My fence was properly permitted. My trash cans were in the approved location. But each investigation meant county inspectors showing up, asking questions, creating stress. I ended up back in the hospital in mid-April. Another arrhythmia episode, this one bad enough that Dr. Rahman kept me overnight for observation. When he came to check on me the next morning, he was furious. "Your stress levels are through the roof," he said. "Your blood pressure is elevated. Your heart is showing signs of strain." "What is going on, Quinton?" I told him everything. About Brenda, the HOA, the constant harassment, the violations, the stress of fighting battles every single day just to live in my own home. Dr. Rahman listened with increasing concern. When I finished, he shook his head. "This is medically dangerous. The stress could kill you. I am going to write a letter to your attorney and to the court explaining that this harassment is creating a life-threatening medical situation." He did more than that. He wrote a detailed 4-page letter explaining how chronic stress affects heart patients, how my specific condition made me vulnerable to stress-induced cardiac events, and how the ongoing harassment from the HOA was creating a significant health risk. He stated in no uncertain terms that if this continued, I was at serious risk of sudden cardiac death. Sarah filed an emergency motion, attaching Dr. Rahman's letter and requesting an immediate hearing. The judge granted it. We appeared in Maricopa County Superior Court on April 23rd before Judge Andrea Sullivan. The courtroom was formal and intimidating, but Judge Sullivan had a reputation for being fair and not tolerating nonsense. The HOA was represented by their attorney, a slick guy named Richard Baxter who specialized in HOA law. Brenda was there too, sitting in the gallery with David Price. Sarah presented our case. She laid out the timeline of events, the medical documentation, the pattern of harassment, the escalating violations, and Dr. Rahman's letter. She argued that the HOA was engaging in disability discrimination, and that the ongoing harassment was creating an immediate threat to my health and safety. Baxter argued that the HOA was simply enforcing its covenant, and that I was welcome to remain in my home as long as I complied with the rules like everyone else. He claimed there was no discrimination and that the violations were legitimate. Judge Sullivan listened to both sides, reviewed the documents, and asked pointed questions. She seemed particularly interested in the photos Robert had taken showing similar or worse violations on other properties that had not been cited. "Mr. Baxter, can you explain why your client issued 5 violation notices to Mr. Larson in 2 weeks, but has not issued any similar notices to other properties with identical issues?" she asked. Baxter stammered something about complaint-driven enforcement and limited resources. "That is selective enforcement," Judge Sullivan said, "and when it follows immediately after Mr. Larson exercised his legal right to medical care, it certainly looks like retaliation." She reviewed more documents. "I am also troubled by Miss Carmichael's repeated contact with law enforcement and county agencies making complaints that were subsequently found to be baseless. That suggests harassment rather than good faith covenant enforcement." She set down her papers and looked directly at Baxter. "Here is what is going to happen. I am issuing a temporary restraining order against the Saguaro Hills HOA. Effective immediately, your client is prohibited from issuing any new violation notices to Mr. Larson without prior court approval. All existing fines are suspended pending resolution of the discrimination claim. Miss Carmichael is personally prohibited from contacting Mr. Larson or visiting his property. Any violation of this order will result in contempt charges. Do you understand?" Baxter nodded stiffly. "Yes, Your Honor. Furthermore, I am fast-tracking the discrimination hearing. We will reconvene in 6 weeks for a full hearing on the merits. In the meantime, Mr. Larson is free to receive his medical care without interference, and the HOA will leave him alone. Am I clear?" "Yes, Your Honor," Baxter said again. I felt relief wash over me so strongly I almost got dizzy. Sarah squeezed my arm. As we left the courtroom, I could see Brenda in the hallway talking heatedly with Baxter. She looked over at me with pure venom in her eyes. Even with a restraining order, I did not feel safe. The next few weeks were better. The lifeguard van came every morning. No violation notices appeared in my mailbox. Brenda stayed away from my property. I started to feel like I could breathe again. My heart readings improved. Dr. Rahman was pleased with my progress. Nurse Patricia joked that I was becoming her easiest patient again. But I should have known it was not over. On May 15th, 3 weeks before our scheduled hearing, I woke up to find my garage door spray painted with the words "Sick Freeloader, Get Out." The paint was bright red, impossible to miss, dripping down the white door like blood. I called the police immediately. Officer Chen responded again, along with a detective named Martinez who specialized in property crimes. They took photos, collected paint samples, interviewed neighbors. No one had seen anything. The vandalism had happened sometime between midnight and 5 a.m. "Do you have security cameras?" Detective Martinez asked. "No," I admitted. "I never needed them before." "You might want to invest in some. Do you have any idea who might have done this?" I told him about Brenda, the HOA dispute, the restraining order. His expression darkened. "If someone with a restraining order is harassing you, that is a serious violation. But we need proof. The paint and the message suggest someone who is very angry with you. Make a list of anyone who might have a grudge." The problem was, I could not think of anyone except Brenda. And while I absolutely believed she was behind it, I had no proof. She was too smart to get caught on camera. Sarah filed an emergency motion reporting the vandalism and requesting the court hold Brenda in contempt. But without evidence directly linking her to the crime, the judge's hands were tied. She issued a warning and reminded Brenda of the restraining order terms, but that was all she could do. I paid $1,200 to have my garage door professionally cleaned and repainted. The words came off, but I could still see them every time I looked at that door. The next incident happened a week later. I went out to get in my car and found all 4 tires slashed, deep, vicious cuts that left them completely deflated. Another police report, more photos, no witnesses, no proof. "This is escalating," Detective Martinez told me. Whoever is doing this is getting bolder. You need cameras and you need to be careful. People who do this kind of thing sometimes graduate to more serious violence. I bought security cameras that weekend. Front door, back door, driveway, garage. I installed them myself with shaking hands, my heart monitor beeping warnings that my pulse was too high. 3 nights later, at 2:17 a.m., my cameras caught a figure approaching my house. They were wearing dark clothes and a hood, face covered. The person walked up to my front door and did something I could not quite see on the camera, then quickly left. The whole thing took less than 30 seconds. When I checked my front door the next morning, I found a dead rat nailed to it with a note that said, "Next time IT will be you." I called 911. Officer Chen responded again, along with Detective Martinez. They reviewed the camera footage, but the figure was impossible to identify. Wrong height and build to be Brenda, but that did not mean she had not sent someone else. "This is a credible threat," Detective Martinez said grimly, "especially combined with the previous incidents. We are going to increase patrols in your neighborhood, and I strongly suggest you stay with someone else for a while until we figure out who is behind this." I stayed with Robert Henderson for the next week. His wife Helen made up their guest room and they refused to take any money. Robert was angry on my behalf. "This is insane," he said. "Someone in our neighborhood is doing this, and I bet I know who. Brenda has been acting strange lately. Paranoid. She stopped me last week and asked if I had been talking to reporters about the HOA. I told her no, and she did not believe me. The full hearing was scheduled for June 6th. As the date approached, the harassment stopped. No more vandalism, no more threats. It felt like the calm before a storm. Sarah prepared extensively. She had my medical records, the violation notices, the photos showing selective enforcement, the restraining order, documentation of the vandalism and threats, camera footage, police reports. She also had affidavits from Robert and several other neighbors attesting to Brenda's behavior and the lack of enforcement against other properties. The hearing lasted all day. Judge Sullivan's courtroom was packed with people from the neighborhood. Tom Fletcher was there, and Margaret Wu. Several other homeowners came to support me. Brenda sat at the defense table with Baxter, looking calm and collected. She had dressed professionally, hair perfect, makeup subtle. She looked like a reasonable person, not someone who had spent months making my life hell. Sarah went first, laying out the entire case: medical discrimination, selective enforcement, harassment, retaliation. She walked through every violation notice, every fine, every incident. She called Nurse Patricia as a witness, who testified about the medical necessity of the daily visits and how the stress had affected my health. She called Dr. Rahman, who testified via video conference about my condition and the danger the harassment posed. Then she called me. I testified about everything. About Brenda's first confrontation, the police being called, the HOA hearing, the escalating violations, the vandalism, the threats. I explained how the constant stress affected my health, how I ended up hospitalized, how I feared for my safety in my own home. Baxter cross-examined me, trying to suggest I was exaggerating or being oversensitive. Sarah objected repeatedly, and Judge Sullivan sustained most of the objections. Then it was the HOA's turn. Baxter called Brenda to the stand. She testified that she was simply doing her job as HOA president, enforcing the covenants that all homeowners had agreed to. She claimed the medical van was a legitimate violation and that she had tried to work with me to find alternatives. She denied any harassment and suggested that the other violations were routine enforcement. When Sarah cross-examined her, things got interesting. "Miss Carmichael, You issued 5 violation notices to Mr. Larson in a 2-week period in April, correct? If that is what the records show, yes. And how many violation notices did you issue to other properties during that same period? Brenda hesitated. I would have to check the records. Sarah pulled out a document. I have checked the records. The answer is 0. You issued 0 violation notices to any other property during those 2 weeks. In fact, in the entire month of April, Mr. Larson received 15 violation notices, and all other properties combined received 2. Does that seem like fair enforcement to you? Different properties have different issues, Brenda said stiffly. Do they? Sarah displayed the photos Robert had taken. This is your property, Miss Carmichael. Your grass is clearly the same length as Mr. Larson's, yet you did not cite yourself. This is David Price's property. His mailbox is actually 6 inches forward of the property line, worse than the alleged violation you cited Mr. Larson for. This is Linda Morrison's property. She has a crack in her driveway twice as large as Mr. Larson's. None of these properties received violations. Why not? I was not aware of those issues. You walk through this neighborhood constantly taking photos and measurements. Are you telling the court you simply did not notice violations on your own property? Brenda's jaw tightened. I cannot monitor every single property every single day. But you monitored Mr. Larson's property every single day, did you not? In fact, you visited his property so frequently that the judge had to issue a restraining order. Why were you so focused on Mr. Larson specifically? He was in violation of the covenants. Because of a medical service vehicle that federal law protects. I did not know that at the time. Sarah pulled out another document. But you did know that, Miss Carmichael. Lifeguard Medical Services sent you a detailed letter on March 20th explaining the legal protections. You received that letter, correct? I may have. Yes or no, Miss Carmichael? Did you receive a letter from Lifeguard's legal department explaining that medical service vehicles are protected under federal law? Yes, Brenda admitted. And after receiving that letter, which clearly explained the law, you continued to issue violation notices and fines to Mr. Larson. In fact, you escalated your enforcement. Why? The HOA board had not made a final decision on the medical exception at that time. But federal law does not require HOA board approval. The law is the law, regardless of what your board decides. You were told this was illegal and you did it anyway. Is that correct? Brenda's facade was cracking. I was protecting property values. By harassing a disabled man. By calling the police on his medical provider. By issuing fines that you knew were legally baseless. I object, Baxter said. Argumentative. Sustained, Judge Sullivan said. Move on, Miss Kowalski. Sarah moved on. She questioned Brenda about every single interaction, every violation, every escalation. By the end, Brenda was visibly frustrated, her answers short and defensive. Then Sarah asked the question I had been waiting for. Miss Carmichael, do you know anything about vandalism at Mr. Larson's property? Specifically, his garage door being spray painted and his tires being slashed? Absolutely not, Brenda said firmly. I had nothing to do with that. What about the dead rat nailed to his door with a threatening note? That is disgusting. I would never do such a thing. Where were you on the night of May 22nd between midnight and 3 a.m.? I was home asleep. Can anyone verify that, my husband? Your husband who is not here today, your husband who did not provide an affidavit or testify. Brenda glared. I do not appreciate what you are implying. I am not implying anything, Miss Carmichael. I am simply noting that you have no alibi for the night Mr. Larson received a death threat on his property. I was home, Brenda repeated coldly. Sarah let it hang there for a moment, then said she had no further questions. The last witness was Tom Fletcher, who testified that several board members had tried to resolve the situation amicably, but Brenda had blocked every attempt at compromise. He stated his belief that Brenda had become personally fixated on the issue, and that her behavior went beyond normal covenant enforcement. After all testimony concluded, both attorneys gave closing arguments. Then we waited while Judge Sullivan reviewed her notes. Finally, she looked up. "I have heard enough," she said. "This is one of the clearest cases of disability discrimination and selective enforcement I have encountered. Miss Carmichael, you were informed repeatedly that your actions violated federal law, and you persisted anyway. You issued violations to Mr. Larson that you did not enforce against other properties. You harassed him, interfered with his medical care, and created a pattern of behavior that any reasonable person would find retaliatory." She turned to the HOA's table. "The Fair Housing Act and the Americans with Disabilities Act exist specifically to prevent this kind of discrimination. Mr. Larson has a documented disability that requires regular medical monitoring. That is not optional. That is not negotiable, and your HOA cannot prevent it. Therefore, I find in favor of Mr. Larson on all counts. All fines issued to him are permanently dismissed and must be removed from HOA records. The temporary restraining order is now permanent. Miss Carmichael is prohibited from any contact with Mr. Larson or enforcement action against his property. The HOA must immediately adopt a written policy exempting documented medical service vehicles from all parking restrictions. Furthermore, the HOA must pay Mr. Larson's legal fees and compensatory damages. Sarah had asked for $25,000 in damages to cover my medical bills, lost wages from my hospitalization, the cost of repairing my garage door and replacing my tires, and emotional distress. Judge Sullivan awarded $50,000. This behavior was egregious enough to warrant punitive damages, she explained. HOAs are not above the law. When they violate federal civil rights statutes, there are consequences. Brenda's face went white. Baxter started to object, but Judge Sullivan cut him off. "One more thing," the judge said. "I am referring this matter to the Arizona Attorney General's office for potential criminal investigation. The vandalism and threats against Mr. Larson occurred while a restraining order was in effect. If Miss Carmichael was involved in any way, that is criminal contempt at minimum. The police investigation will continue." She banged her gavel. "We are adjourned." I sat there feeling stunned. Sarah was grinning. "We won. We actually won." People crowded around me afterward, congratulating me, expressing relief. Robert gave me a bear hug. Tom Fletcher shook my hand and apologized profusely on behalf of the board. Brenda left quickly, Baxter hurrying after her. I watched her go, feeling not triumph but exhaustion. The Arizona Attorney General's office did investigate. Detective Martinez worked with their Civil Rights Division, and they subpoenaed Brenda's phone records, financial records, and security camera footage from her house. What they found was damning. Text messages between Brenda and David Price discussing making Larson regret fighting the HOA. A receipt from a hardware store for red spray paint purchased the day before my garage was vandalized. Cell phone location data placing her phone 3 blocks from my house on the night of the rat incident, even though she had claimed to be home asleep. Most tellingly, they found footage from a neighbor's security camera that had a partial view of my street. The figure caught on my cameras walking to my house was captured from a different angle on the neighbor's camera. While the face was still obscured, the clothing matched an outfit found in Brenda's closet, and the gait analysis matched her walk. On July 3rd, Brenda Carmichael was arrested and charged with stalking, vandalism, criminal threats, and violation of a restraining order. David Price was charged as an accomplice for his involvement in planning the harassment. The story made the local news. HOA president arrested for harassing disabled homeowner. Read the headline in the Arizona Republic. It detailed the case, the discrimination, the vandalism, the threats. The fallout was swift. The HOA board held an emergency meeting and removed Brenda as president. Tom Fletcher took over temporarily. They issued a formal apology to me and changed several policies to prevent future abuse. The HOA's insurance company settled my claim for the full $50,000 plus an additional $20,000 to avoid further litigation. I used some of the money to pay off my medical bills and put the rest in savings for future health expenses. Brenda took a plea deal in August. She pleaded guilty to stalking and violating a restraining order. The other charges were dropped. She was sentenced to 6 months in county jail, 3 years of probation, and was required to undergo psychological evaluation and anger management counseling. She and her husband sold their house and moved out of the neighborhood before she started her jail sentence. David Price got probation and community service. He also moved away. The new HOA board, with Tom as president and Margaret as vice president, turned out to be reasonable. They created clear medical accommodation policies. They stopped selective enforcement. They focused on actual community improvement rather than petty rule violations. The lifeguard van still arrives at my house every morning at 9. Nurse Patricia still checks my vitals. My heart condition is stable, and Dr. Rahman says my stress levels are the best they have been in a year. I still live at 4256 Desert Rose Drive. I installed a nice garden in my front yard, and no one has measured my grass or complained about my mailbox. Robert and Helen come over for dinner once a week. The neighborhood feels like a community again instead of a battlefield. Sometimes, I think about how close I came to losing everything because one person decided that her vision of a perfect neighborhood was more important than my life. How the law protected me, but only after months of stress and fear and fighting. How expensive it was, in every sense, to simply exist in my own home. I think about all the people who face similar situations, but do not have lawyers like Sarah or doctors like Dr. Rahman or neighbors like Robert. People who get crushed by HOAs because they cannot afford to fight back or do not know their rights. People who give up or move away or suffer in silence. The system worked for me, eventually. But it should not have taken a federal lawsuit, $50,000 in damages, and criminal charges to get someone to understand that medical care is not negotiable. I am grateful it is over. I am grateful I survived, both literally and figuratively. And I am grateful that when I wake up every morning and see that white van with the blue medical cross pull into my driveway, I know it is legal, it is necessary, and no one can take it away from me ever again.